All right, we'll go ahead and call to order our Judiciary Committee meeting today. If you would, as we always do, if you would bow your heads with me, we will begin our meeting with a word of prayer. Lord, we thank you for allowing us to pause now, and we ask, as we always do, that in this room your wisdom would be with us and give us the knowledge that we need to do what is best for the people of this great state. Thank you for all the blessings that we do have, Lord. We particularly want to remember at this time all the sickness that there is here in the legislature and, of course, the nation and our state as we deal with the latest version of the flu. Lord, there are people suffering, and we ask for your blessings to be upon them. Amen. All right, Representative Estration, Chairman Estration, you have a bill, and before we do that, though, I do want to recognize our members of the Judiciary that we have here with us today. Judge Brenda Weaver, there she is in the front row, and next to her is Judge Dusty Hightower, former member of this legislature. As always, we certainly do appreciate y'all being with us today and coming down and keeping us straight. Thank you so much. Welcome. Do we have any other members of the Judiciary with us that I may have missed? I don't think so. All right, Chairman Estration, why don't you tell us about the substitute to House Bill 544?
Well, thank you, Mr. Chairman. Constituent brought an issue to me that's received some media coverage where her family member was subject of an involuntary, it's an order to apprehend, which came into a 1013, and the concerns specifically, there were several concerns, but one of them was law enforcement attempting to effectuate the order was unaware of the circumstances that a family member had observed, which brought the order about, or brought the need for the order. And so initially I introduced House Bill 544 with her support to work to address some of the issues she had raised. Ultimately, Representative Oliver and I sat for a study committee over the summer to work on this issue. It's a very complex issue that involves many important different considerations. I had a substitute that I presented to the Kelly subcommittee earlier this session, and after that I've been in conversations with the probate court judges, and ultimately we have a compromise proposal that's before you today is this substitute. And really what we're doing is this. Currently a person, there's two different statutes that allow for an involuntary commitment. One would be for mental health issues, another would be substance abuse or alcohol issues. And what this would allow for is inclusion of the affidavits. There is a requirement for two people to sign affidavits for the court to issue one of these orders, for inclusion of the affidavits after the personal information has been redacted to both the report issued to law enforcement and to the medical report received at the treating facility. And so it's my expectation that we've addressed all the concerns. This does not address all of the issues that my constituent originally raised, and she actually testified before the Kelly subcommittee. But what I'm planning to do is to refer many of those difficult but very important issues to further study in an appropriate commissioner board that can handle those important considerations going forward. So I'd ask for your favorable consideration of this substitute, and I'd be happy to answer any questions.
Questions of Chairman Estration. And you did say that you had worked through some of the issues that the probate court judges had with
Yes, sir. It's my understanding that the probate court judges, now granted, this substitute is really just was ready today, and I'm grateful to the committee for letting me hear it, but the probate court had said that this was acceptable, that this concept was acceptable to, they could live with it and they'd be fine with it, and I'm comfortable proceeding with this.
Ms. Oliver?
I want to thank Chairman Estration for the work on this. Probate courts need to hear from the family, and the family, the people that are closest to the person who's in crisis, really, that information needs to go forward. There's no downside to that information going forward to law enforcement or to the receiving facility. I think this is a good compromise, and the Behavioral Health Commission has a special subcommittee on this, but this is a good first step.
Thank you.
Thank you, Ms. Oliver. Any other questions from committee members? We do not have anybody signed up for this particular bill. So if there are no further questions of the author of the bill, is there a motion?
Move to pass.
There's a motion to pass and a second. This would be by committee substitute. Any further discussion? Hearing none, all those in favor, please indicate by saying aye. Aye. Any opposed? You move on to rules. Thank you, Mr. Chairman. All right, Mr. Saints. Representative Saints, why don't you come forward, Saints, and tell us about House Bill 452, and I think that is also a substitute, isn't that correct?
Yes, sir.
Okay. You want to introduce your guest as well? He can introduce himself if you want him to.
Thank you, Mr. Chairman, member of committees. House Bill 452 is related to the Department of Revenue, requested by the Department of Revenue to allow them to use a bank match system. Director Scott Purvis with the Compliance Division of Department of Revenue is here to aid me in any details the committee may have. This bill did pass this committee last year. It was under a different code section. This current substitute allows it to be in a more traditional area. With that came several modifications. We've worked with the credit union and the Banks Association, making several modifications. They may have a few comments that I'm sure they'll be allowed to make, but in essence, this allows for a more efficient utilization of the system we have to collect delinquent taxes in the state, within the state of Georgia and outside, that has been adjudicated to be owed, and takes it from a paper process that creates first burden with the department, but also burden with the institutions when they receive a request that does not have resources behind it, because of, again, the department's best ability to look at where these resources are is not a guess, but close to it. This bank match system is currently utilized by the state of Georgia in collection of delinquent child support payments. It would be the connected vendor to do so, that would do so, and this would allow for a more efficient process. With that, if it's to the benefit of the committee, I'd ask the director to add anything you'd like.
Mr. Purvis,
you, Mr.
please
Chairman.
introduce yourself.
Thank you, Mr. Chairman. My name is Scott Purvis. I'm with the Georgia Department of Revenue. I'm the director of the Compliance Division, and we're the division everybody loves to hate. It started back in Jesus' time, and I have good news for you. Nothing has changed since Jesus' time. Our charge is to collect the delinquent taxes for the state of Georgia, and as we move forward, our goal is not to get bigger, not to get stronger, but to get more efficient. Last year, we issued 9,915 bank levies, where we sent out pieces of paper via facsimile or scan and email. Of those 9,900, about 6,100 of them were productive. In other words, we found money on deposit for the taxpayer, and we seized that money. Our goal is to make that process more efficient. We also have the option, when we locate the funds, do we need to seize the money? Our goal is generally to get the taxpayer to voluntarily comply, enter into a payment agreement, and come up with a satisfactory arrangement with the Department of Revenue. And this is just another tool in our work bag to allow us to do that. As the representative mentioned, the Department of Family and Children's Services use this as a third-party vendor, the same one that we would attempt to use and hopefully be able to sole source, because they are currently working with 34 different state Department of Revenues, as well as some other financial matches that they do for child support, things like that, throughout the United States. Our neighboring states, both North Carolina, South Carolina, and Alabama, all use the same system that we're attempting to pass laws for too. I'd be glad to answer any questions.
So I do want you to walk us through the legislation here in just a second.
Sure.
But the idea is you already have the ability to do this.
We do. What we're looking for, we already have the ability to seize
The legal
funds.
right to do
Yes,
this,
sir.
let's put it that
Well,
way.
what we would do is, if you were looking at days gone by, we would publish a list of liens that were recorded. We do that electronically now and eliminate those paper liens. That lien, once is recorded with Clerk of Superior Court, gives us certain levy authority. That levy authority means if we can find funds on deposit, find money, find personal property, we can seize that money. So we do currently have that capability now. We're just looking to make it a little more efficient.
And this third-party entity that all these other states work with, tell me what they do for you and how that works.
The company's name is Informatics.
Mhm.
We basically take I guess for lack of a better word, a list of delinquent taxpayers where we have recorded that lien.
Mhm.
We give that list to the third-party vendor. The third-party vendor is already reaching out to all other financial institutions, doing data match to try to find information.
Child support recovery, you said, for
Correct.
example. Yeah.
They're doing that now. So we would basically piggyback on that data match. As they send it out, they would get the information, send it back to us and say, hey, we found funds on deposit. Another benefit for DOR is these funds may be outside the state of Georgia that we don't normally have the ability to locate.
And they'll search nationwide for you for
They
the
will.
delinquent taxpayer,
It's
just
up to
like
the
they would for
state.
some child care,
Exactly.
child support recovery.
That's exactly
Okay.
right.
Okay. And is this legislation to allow you to work with that technology company that does this
Exactly.
in other areas? Okay.
Yes, sir.
Okay.
That's what we're looking to do. And as mentioned earlier, we had a bill last year. We just tried to hijack another title section in the law, and it didn't work well. We needed this under Title 48 because that's where the DOR operates. It just fit our needs better to be under Title 48.
Okay. Why don't you, do you have a general question, Mr. Lewinsky, before we walk through the bill, or would you like to ask it now? You want to walk through it? Okay. All right. All right. Why don't you take us through, Mr. Purvis, we have, I guess, really one big section, so.
We do. We go through the first section of the bill, we actually define what a delinquent taxpayer is, and which is already defined in the code section.
You're just referencing it, yeah.
That's right, as
Okay.
well as the financial institution. We had to be real careful with the definition of financial institution because some of the levy powers we use now reach out to individual retirement accounts or funds that might be on deposit with an insurance company. Our goal was never to wrap insurance companies into this program, and they had a little bit of objection as well. Again, we would only be matching through financial institutions that were already participating in this program. We would do that, and you see in line 23, we would actually do it 4 times a year, once a quarter. We would update our list of delinquent taxpayers with the third-party vendor. Again, it references that we have filed an execution. That's the lien that we recorded in accordance with Chapter 3. The financial institutions, up on line 26, within 30 days after they received a request for the information, they would give an electronic format back saying, hey, basically here are the hits that we found on the data that you sent to us. Section D just authorizes the department to enter in agreements with the financial institutions to develop that automatic data exchange. Section E is really what spells out the allowance of using that third-party vendor that we mentioned. They're already doing this, as I said, in other states. We would try to sole source them to use the same thing because they're already doing the process, as well as inside the state of Georgia. Down in Section F, the department may use the information received only to code section to enforce collection of taxes. That's our disclaimer to say, hey, we can only use this to collect delinquent taxes, nothing else. And again, these are taxes that we've already gone through the due process. We've sent them a gazillion bills, and we have issued and recorded a lien before we reach out to try to take this action. And line 50, the extent possible, compliance with federal state law, department administer the code section, and referencing the Article 1, Chapter 11 of Title 19, that is the section of the law that deals with child support recovery's ability to use the same program. The disclosure is mentioned down towards the bottom. Disclosing information to the department is basically for us to say, hey, we do not want the financial institution to reach out to the taxpayer and say, hey, Department of Revenue is trying to take your money. You need to make sure you move it somewhere. Again, in line 65, any financial records obtained can only be used for administration enforcement of tax laws. The department has not established procedures, rules, and regs for these data matches since we don't have the law. Line 68 gives us the ability to do that. And then the bottom section there, lines 74 through 78, allows the financial institution to make a charge against the account that if we levy money out of the account, they may charge a fee not less than 20, not more than 50, to be deducted before they send us any funds. In other words, they would have the right of first offset to seize that fee before they submitted money to the department.
It is always comforting to me when I can compare something that we're about to allow you to do to something that's already done. Because that means that this path has been worn and we know where we're going, so to speak.
Yes, sir, absolutely.
So
We share that same feeling.
The question I have for you, I'm somewhat familiar with child support recovery. That's something that we've been doing for a long time, and I think successfully in the state, collecting those monies from people that owe it. We already have a lien law which allows you to collect from folks. So what I'm looking for here is the differences. Is there anything new that we're doing here relative to those two topics, liens and how we do it somewhere else? Miss Oliver says the fee.
The fee is, and I guess that depends on which fee you're referring to.
Let me turn your mic on, Miss Oliver. You 13.
I didn't mean to interrupt. I thought
No.
I thought you were really thinking about the fee.
You know what I'm looking for.
There's federal limitations on fees for child support recovery. So when does the child support recovery, the bank charge child support recovery $20 to $50 fee, or do you know?
I do not know.
Where did the $20 to $50 fee come from? How does that who thought up $20 to $50?
Where did it come from? Right now, if the Department of Revenue serves a bank levy to a financial institution, the financial institution can charge a fee to the taxpayer. So we're just rolling that financial levy information into this same bill.
Are you saying that $20 to $50 is somewhere set out in some business standard about some fee? I'm just curious where the number came from.
I've been told, and we parallel the child support on that fee. It's parallel to the child support payment. Now there's an additional, the fee that they can take off the account is the same. I think the bank association, if they still have a comment, might have a comment on an additional fee that is included in child support and possibly not included in the bill.
If I may, Mr. Chairman, one more. Does IRS
Please.
use this technology? Federal tax collector?
I do not know. They certainly would have the ability to, and the third-party vendor that we have spoken to has. There was a question someone asked early on in the formation of the bill that wasn't this deemed illegal or irresponsible. We reached out to the third-party vendor and they said, "Gosh, no, the IRS does not do it, but it's mainly because of a administrative issue. I don't know that they've pursued it."
The IRS seizes bank accounts all the time.
Oh yeah, they do it the same way we do through a bank levy or a financial institution levy. We used to do it in person where we would take a piece of paper to the bank. Of course, now with the way banks have evolved over the years, they want one location for those financial institution levies. So we take, or now basically everything we do is via email,
Digital.
Fax machine. We have this thing now called the internet that makes it a whole lot easier.
I'm just trying to figure out the fee, whether it's.
Well, you did say that it was the same. You mirrored what's done with child support recovery, right? Yes. You want to introduce yourself and come forward? Please do. Yeah. Mm-hmm. Yeah. Come on up. Tell us who you are, and we'd be happy to hear from you.
Hi, my name is Amy Casey. I'm a staff attorney with the department.
Okay. Amy Casey?
Yes, sir.
Okay. Ms. Casey, good to have you.
Oh, thank you. I'm happy to be here. Essentially, to my understanding, this was pulled directly from the child support statutes.
Okay.
But I'm happy to verify and come back with a citation if you would like.
Well, I think Ms. Oliver had the question, and I'll let her ask you from there.
What's confusing to me is a child support federal statute would tell a bank how much it can charge. That's the connection I'm trying to make in my mind. The amount of the charge is. There are probably some banking people are listening to me closely.
We've got some signed up to talk.
Okay,
Yeah.
good. Then I'll hush.
Yeah, but I think what on line 75 should provide maybe some answer to your question is that there is a cap there, so you can't go over a certain amount. I think we would probably want that cap there.
Oh, yeah.
Yeah. All right. Some other questions, Mr. Lewinsky. You've been patient.
Thank you, Chair. I guess this goes back to whether this was pulled directly from another statute, but on line 29, when it says intangible property from the financial institution, just what intangible property would they be looking for from an insurance company?
anything that would be a mutual bond, what we find with mutual bonds and things like that have a financial, any type, insurance companies now actually get into the financial institution business, but it is rare, but occasionally we'll find.
Should we look into that?
into?
Sorry, joking.
Any mutual funds or anything that they had on deposit, we find certificates of deposit, CDs, that are held with insurance companies now.
All right, thank you. That's all, Chair. Thank you.
Mr. Wilson? Oh, Ms. Casey, did you want to comment? Go ahead.
And I would just like to point out that we're currently in discussion with the insurance companies to figure out some mutually agreeable language if there's any remaining uncomfort.
Okay. Mr. Wilson?
My question is about the information that you obtain. I think reading through this, I think I know the answer to my question, but I want to see if you can shed some more light on this. I understand as you go through this process, you might gather information about the individual, and I see several subsections here or paragraphs where that information is to be treated as confidential tax information and not to be disclosed. My question is, can the department share any information that it uncovers about a person, additional information, with the IRS?
Well, the IRS, not with that. I mean, they're still protected by taxpayer confidentiality.
Move your microphone.
I'm sorry. The taxpayer is protected from the IRS. Now, we are in a program with the IRS. If someone gets a state refund and they owe the Internal Revenue Service, the Internal Revenue Service can offset that refund. We're in a reciprocal agreement where we do the same thing. As a matter of fact, we have to send a certified letter to a taxpayer that says, hey, if you get a federal refund, we may offset it this year. We set a record last week with one transmission from the federal government. It was $23 million, 40,122 refunds offset at one time. I've been with Department of Revenue for 26 years, and that was the single biggest transmission we've seen from the Internal Revenue Service. They have the ability to do the same, but not gather information from the taxpayer. They share information with us that is protected under Pub 75 confidentiality, where we, if someone files a federal return, they live in Georgia, and they may not have filed a state return, they send us a tape. We run that tape to see if that taxpayer has filed a Georgia return. But as far as sharing information back and forth, it's kind of a one-way street. Same way with the other agencies that we might have an MOU with.
Okay. Thank you.
Yes, sir.
Mr. Meyer?
This is just going back to Representative Oliver for the mirrored code section on the fees. It does mirror code section 19-11-30.11. 30.11.
That's the child support recovery section. Okay. Representative Bruce?
Hi, I'm just trying to make sure I understand all of this. Is this basically saying that a company that, if I get sick and I make a claim, that whoever is paying my claim has to disclose the information to you as to how much they're paying me? Is that?
No, sir. What this would be is if you had a liability with Department of Revenue and we sent this information up to the financial institution, said, hey, see if you can find any information on John Smith, funds on deposit, they would send us back a match and say, we found this money on deposit. Wouldn't have anything to do with a claim necessarily.
Okay, because I guess I'm trying to see the connection here with the medical and
With
child
insurance
care.
company.
Yeah, and I'm
Sure.
not getting it.
And you're right. There would be no correlation. A medical claim is separate from money that might be held by a certificate deposit or something that an insurance company had. In other words, if I had a benefit that was being paid to a insurance company and Department of Revenue wanted to levy on it, they could levy on that benefit. With some withstandings, there are certain benefits and certain income that is not subject to levy for Department of Revenue. One of those would be medical claims and things like that. They're already exempt from levy. Social Security benefits, things like that are exempt from levy.
Okay.
All right. I don't see no further questions from the committee at this time. We do have one person signed up, Miss Elizabeth Chandler. She's hiding behind the pole. Yeah, slide over and she can sit right there. Miss Chandler, welcome. Good to see you. Come on up, and if you would, introduce yourself, and we'd be happy to hear from you.
Thank you very much, Mr. Chairman and members of the committee. I'm Elizabeth Chandler. I'm with the Georgia Bankers Association. And I just wanted to comment briefly and thank Representative Saines for the new substitute and taking into account a few comments that we had over the last week. And I apologize. We're just getting our arms around some of this. And I was involved in the conversations when the first data match went into statute with the Department of Human Services. And
For child support recovery.
That's right.
Right, okay.
Yes. After Congress, I think, essentially told the states to do this after welfare reform. I think it was the late 90s when all this was put into place. So comparing that to what our member banks currently do when responding to a request for data match, there are just a few remaining inconsistencies. And so as not to create any undue burden, we would love to keep talking, and I think that's where we are. So with that being said, I know the timing of the session at this moment is very precarious, but I think we've got good communication going, and we'd like to keep chatting.
Anything in particular that you want us to change in the substitute this
Well,
proposed?
I wish I had specific language for you today. A couple of things that have jumped out at us. To Representative Walensky's point on the term intangible property, I think we would be more comfortable knowing exactly how that might be defined. You know, we were wondering if it might include collateral on a loan that our member banks may be holding. Would it include safe deposit boxes, that sort of thing? Those are things we don't currently match against for child support recovery. And another issue is the subject, in addition to the fee that could be debited to an individual's account. DHS allows for banks to recover cost associated with running the match, not to exceed the cost. It's certainly no profit center. It's just a reimbursement for running the match, and whether that's done directly with a bank or through their core processor, there's a cost associated.
This is a different charge than the $20 to $50.
That's right. Mm-hmm.
Okay. What are we talking about in that instance? Do you have any idea?
Cost-wise, I do not know off the top of my head.
Okay.
We're trying to find out from some core processors
Okay.
what they currently charge.
All right. Mr. Walensky, you had a question?
Thank you, Chair. It was more just a comment. That was my concern about intangible properties. How broad is it? I mean, if an insurance company has information from any of, from bank accounts to, through every course of application you ever done, would they have to turn over everything that wasn't directly something they held? So I was just worried about the broadness of intangible property.
Right.
And that would not be the intent. We actually have the ability to levy on those funds now, but it would not be through this program. This is really just to find the located assets.
I think once you have a lien, tax lien, you can levy on anything, just like if you had a judgment from the court. If you have a car, they could actually levy on the car, or if you had property, or if you had, just trying to think, any tangible property, real property, you could levy on that too. So the lien process, which they're taking advantage of, is already in existence, used by attorneys when we collect judgments. I got the impression what we were doing here is allowing them to access new technology that someone allows to do a big search at once, and they're just going to get more hits than the slower process of not using this third party vendor that we already use for child support. That's the impression I had. Now, what I'm want to do with you, Ms. Chandler, is make sure that we get this right. And it sounds like to me you're willing for us to move ahead with this today because you're satisfied that the author of the bill and those that Department of Revenue are working with you and would probably be willing to make change if we found something that was out of the ordinary from what we already do. Is that correct?
Yes.
Okay. I just want to
I
make sure
appreciate
you're
it.
satisfied. Representative Saines, you want to comment on that?
And
Is
just
that-
out of
Yeah.
good faith, line 29, if it's to the pleasure of the committee, the Department of Revenue has reviewed it, and they could change that to accounts instead of intangible property without a quick assessment of it having an impact on the bill.
Is that correct? Change it to accounts? Does that make you feel better? Representative Lewinsky? To get rid of the word intangible property and change it to accounts. You're
Line 29.
on line 29.
Thank you, Chair. I think so, if the committee agrees. I do think I saw it in another place when I was reading it earlier, but I've read a lot of things today.
We'll give you a second. Go ahead and look over it. The word accounts do better for you, Ms. Chandler.
She nodded her head.
Yeah.
Yes, thank
Okay.
Yeah, it's on, thank you to our amazing
Where is
assistant.
it?
Line 72.
Line 72. Is it, see, Miss Casey? How about on line 72? Does that, it says intangible property right at the end of line
Correct.
72.
On
Would that
line
place,
70 yeah,
would
line
that place mess
72
you up to change it to accounts?
They're actually, what it's outlining is the authority that we already have under 48-255.
You can
to
already
seize
seize property,
any
yeah.
intangible property.
Okay,
yes, sir.
so-
And it's what it's referencing. 48-255 is what we operate under when it comes to seizures and levies and things like that. And intangible property is eligible to be seized under 48-255. Again, our intent's not to try to find or add any burden to the financial institutions. We're just trying to seamlessly jump on a process they're already doing, not make them look further, just do what they're already doing now.
You already can seize intangible
Yes,
property
sir. That's correct.
under that code section.
Correct.
But it's for the purpose of the financial institution, it's the word
Match.
accounts on,
On line
line
29,
29.
the word accounts, there are far smarter people than I in the room, namely Amy Casey, and she's happy with that. I'm happy
Okay.
with that as well.
Mr. Walensky, you okay with that? Okay. Any further questions from the committee regarding any portions of the bill for any of our witnesses? And Mr. Walensky, you want to be prepared to make an amendment on line 29 that would change intangible property to accounts? Okay. All right. Okay, thank you. Appreciate y'all being here today. We don't have anybody else signed up. We are back to the committee now. What is the will of the committee? Well, first we make a motion to pass. And Mr. Welch seconds it. All right, so we are now in the process for amendments. Mr. Walensky?
Thank you, Chair. Make a motion to amend line 29, remove intangible property and substitute with accounts.
Is there any objection to the Walensky amendment? Chair, you want to object, Mr. Wilson? Go ahead, Mr. Wilson.
Can I ask,
Absolutely.
is it Representative Walensky's intent to replace the word property with accounts and leave the word intangible?
Intangible property, I thought he mentioned. Was it, did I mishear that?
I said
Take,
intangible.
remove both words?
Yes.
Yes. Change to accounts. Okay. Is there any objection to Mr. Walensky's amendment to remove the words intangible property at the beginning of line 29 and replace it with the word accounts? Hearing none, that is in. All right. We have a do pass recommendation, which will be by committee substitute with, of course, the amendment that we just added. Is there any further discussion or comments from the committee? Hearing none, the chair will call the question. All those in favor, please indicate by saying aye. Any opposed? No opposed. You're off to rules. Okay. Thank you. Appreciate y'all being here today. All righty. Chairman Welch has showed up just in time to tell us about House Bill 1078.
Thank you, Mr. Chairman. 1078 is a technology fee that would be added on to a surcharge that would be added on to convictions or violations, filing of a civil action, and filing of an affidavit, fines paid. However, it will not be paid to, in the substitute, you'll notice that it's not, well, let's see, substitute there. Yeah, it's changed. It won't be collected collected more than once per party within any one action or proceeding. So this is this substitute we favorably approved out of subcommittee. The clarification language was added that that says charged and collected not more than once per party within any one action or proceeding at lines 27 and 28. The purpose of this bill is to address in my home county of Henry County, and it's happened in multiple counties now, where they've tied their servers together between the clerk's office and the county servers, and when hit by a cyber attack, what has happened is that the entire system shut down. So our judiciary shut down, the clerk's office, everything shut down in that system, and trying to recover all that information was very difficult, time-consuming, and costly. This would afford courts within counties, within each circuit, to levy these technology assessments and collect that in order to maintain the software and hardware, to lease and purchase computer equipment, to also put in technology support services and buy cyber security insurance. We're just in a new age where the vulnerabilities are fairly prevalent, and where those things are tied in with another system. Having this fee would be helpful in the in preventing that from occurring, the cyber attacks from occurring if they do occur, to have the insurance to pay for them if necessary, and also to provide the support services and equipment to guard against it. That's the nature of the bill that passed out of subcommittee with that clarifying language that the lines I mentioned, and I'll be happy to take any questions.
You do have some, Ms. Oliver.
When this was in subcommittee, I had a sense that you were talking about Henry County, which you have just then, but this adds a $10 filing fee to every civil action in the state. Is that correct?
It could, yes, it certainly could.
Does the local court have to state, I'm going to add a $10 fee?
It would.
And how many local courts now already charge a technology fee that's less than $10?
I know a few that are at $5. So that I think there has been some general law that has been passed by some probate courts. I think it's a $5 fee. So yes, it does exist, and that's why we have that unless technology fee is already provided for by general law.
When we raised the filing fees, and we raised them substantially, I'm not sure how long ago it was, 10-ish years ago.
About that.
We did so for the purpose of making fees consistent across the state. That was one part of the discussion we had. And we did it also for the purpose of not promoting more add-on fees. And historically, the trial lawyers have objected to generalized raising of fees. So I'm kind of trying to figure out where we are in 2020 on all those issues.
I think those are valid points. I think that the nature of this, what we're trying to target here, a lot of these things, a lot of the add-on fees have been for somebody's pension, some additional resources for law enforcement, some other different types of funds that have been put in place. This directly goes to ensuring the protection of the very electronic database that we have been fighting to install for the last 10 years, and now requiring everybody to submit and file electronically.
Where does that say that it's only for cyberware?
It's in the no,
Line
it's
29.
Look at 20. You go 31 through 37 are all the purposes for which
But
it can be
it's
used.
exclusively for computer hardware and software purchases, lease, I mean, that's everything. And then we have a new one down here, 5, cybersecurity insurance.
All of these are new.
Clerks buy computers now and software purchases.
I understand, but the point of this is now we're requiring everybody to e-file, to electronically file. So we're adding a fee to support the very electronic system that we're now compelling everybody to be a part of. So if we're not going to protect it and provide some levels, we're just increasing the local cost. I think the bill has always been targeted with these things. The only one that I added in subcommittee was cybersecurity insurance. And so it has become the effective backbone of the filing system, whereas it used to be paper docketing. So to protect a file room, from fire or water damage. Now we have everything. Now paper is not the means by which we communicate. It's all e-filing.
So the answer to my question is what's different in 2020 is e-filing, and that's where the trial lawyers don't care anymore, I guess.
I can't answer that question for you about that. I'm just giving you my explanation for why I'm bringing the bill. So I would ask for your favorable consideration, but I know there's other questions. So.
All right. See, Mr. Walensky?
Thank you, Chair. I have several questions. Going along with that, does this $10 fee go to the same place as the $250 filing fee goes?
I couldn't say. I don't recall exactly where the 250 filing fee goes, except it goes to the local clerk, if I remember correctly, but I'm not positive.
And where does this also go to the clerk?
This is part of the, if I remember correctly, this is going to be going into, it is the clerk of courts.
Okay. And right now, when attorneys file and there's a $250 fee, I guess there's no question there. That was a statement. I apologize. All right. So my next question is, it talks about here is not more than once per party within any action. Who decides which party pays and when? How does that occur?
Each party would pay.
Well, Chair,
Yeah, go ahead.
Yeah, I just don't. Where does it say that both parties pay at a certain time? Let's see. Of this pair shall be that
Charged
charged
and
and collected
collected.
not more than once per party. However, it doesn't say that each party must pay.
Well, it says there
Not more than
to
once.
charge and collect a technology fee. So it would be imposed by the local court in terms of the judge. So the chief judge would be able to do that and set the rate.
I may be reading it wrong, but I see where it says that neither party may pay more than once, but I don't see where both parties have to pay, unless it's maybe legally.
It's in the first. The imposition of the fee is on the other page. So a technology fee is charged and collected by the respective court's loan judge. So it's set by them, and then the surcharge is placed for those purposes, or for those different types of surcharges are listed there at lines 20 through 24. We already have a statutory code that imposes these fees, and what we've done is added that to the list.
Is there somewhere that we're seeing where both parties are committed that they both have to pay in this bill based on another? Is it in another code section or is it in this bill?
What do you mean both parties?
Okay, so it says that not more than once per party must pay.
He's on line 27 now.
On line 27. So, but what happens if a court says we're going to have all the plaintiffs pay and not the defendants? I don't see anywhere in this new bill where it limits the courts that it instructs both. If y'all do this, both parties must pay.
All right, so on line 22, if you file civil action, that's a basis for charging the fee. If you file an affidavit, but you're already a party to the action, and you paid as part of that initial complaint, then you would have already paid and you wouldn't be double charged for filing a subsequent affidavit. If you're paying a fine, and that's part of the fine is paid, then as part of a speeding ticket, and that could be the point at which you would pay. So it's dependent on whether you fit into one of those 5 categories.
Okay, so a plaintiff files an action, and it costs $250. Is that $250 part of the technology fee?
No, there's
No.
nowhere in here that says $250.
Right. Okay, and so then the court decides that they're going to charge a technology fee.
So let me see if I can help you there. In order to possibly get charged a $10 fee, and of course what has to happen before that is that the chief judge most likely has to sign an order implementing this $10 fee. And only person he can implement this $10 fee upon, as I read it, is in lines 20, 21, 22, 23, 24. In other words, if you're paying a fine, he can put the $10 fee on you.
I'm with you.
If you get convicted, he can put it on you.
Yes.
If you or I guess there's some violation that you have committed, he can put it on you. And number 23, the filing of an affidavit with the court, he can put it on that, or the filing of a civil action. So you have to have filed a civil action to ever qualify possibly for a judge to put a $10 fee on it.
So-
Did I get that right?
So
There's your category of people that could pay the $10 if the judge ordered it for his court.
okay, so the only people that file civil actions are plaintiffs. So this $10 charge would be charged to just plaintiffs for civil actions.
Well, it could be charged in defense. So if you filed an affidavit, right, and the judge, if you filed a motion for summary judgment on the defense side, and you filed an affidavit along with that motion, then that could be one of the triggers if the judge, by a local order, imposed that.
I agree that, but for civil actions, only people, when you file a civil action, you're a plaintiff. So under line 22, the only people that are going to be charged a $10 fee are plaintiffs.
Under line 22.
Yeah, okay.
His point is the defendant could get hit
Yeah.
under line 23.
Yeah, if there's an affidavit filed. Now,
That's correct.
okay, and then also, there are civil actions in Georgia where it's mandatory to file affidavits, and
But
throughout
you only can get hit once per party. That's the line I on line 27. Charged and collected not more than once per party with any one action. So once if you pay George with the filing fee, you're done.
When it came out when it came out of subcommittee, it did not have that qualifier on there, and I got concerned as it came out, Mayor Margaret, that this could be applied in multiple fashions. So every time you filed something, you'd have to pay $10, and it's supposed to be a one-time charge for the party. That was it.
Okay, Miss Oliver.
Line 23, the end of that is or. So if the chief judge is going to impose, the judges could decide to fine every traffic violator $10.
They could, yes.
That'd be a big moneymaker in DeKalb.
There's some people here who want to testify for it. That may tell you some more information.
Okay, let's see. Number 11 is you, Mr. Wilson.
Yes, sir. Thank you, Mr. Chairman.
Mm-hmm.
And Chairman Welch, I appreciate lines 27 and 28 and trying to limit the impact of this fee over the course of the litigation. My concern is that we're voting on this fee, adding a fee, and I don't have a good understanding of the landscape of all the fees that are currently being charged. I mean, I know when I file suits, the fees that I've encountered in various courts, but I also know that those are particular to the court wherever I am. I wonder, and I'm not meaning to put you on the spot, but I wonder maybe Chairman can help me answer this, or Representative Oliver. Has this committee, or when's the last time the legislature took a holistic view of the fees that we're charging?
2010 was it?
To the best of my ability, that would have been it when there was a big budget crunch in the recession back then. There was several different fees looked at, and I think these were at that time taken a pretty long look at. So that's probably the last time you had a comprehensive review. Ms. Oliver, you want to add to that?
I think you're right, and it was raised substantially from the old fee, which was $50 or something. So it was raised substantially. We were still lower than some of the states around us. But I'm hung up right now about traffic, because the add-ons to traffic offenses are a whole different ball of wax, and are lots. The judge just told me there are 15 different add-ons on traffics. So that's what's making me nervous here about
There's 15
these.
different possible or 15 total? 15 possible. Possible, yeah, because depending on your violation, you could, it doesn't apply to some and it does apply to others, yeah. And sometimes there's a relationship between the violation that occurred and
Does this fee only apply to Superior Court?
No.
No.
the chief judge of a state court, I would suspect, the way it's written, or it could be the probate court, I suspect.
Do my colleagues to my right here, if we changed it to take out the violations and the fine paid, would that make it? Because then you're just dealing with the file, moving into court. You're convicted, obviously, of something that I don't know that it solves your problem, because it still would be the conviction would be the
All
end
right,
of it.
conviction, what's the difference between conviction and fine for the purpose of interpreting this on a local level? I wish I knew how many counties judicial circuits had imposed technology fees, because I can't remember even if DeKalb has imposed that.
It's just a handful.
Yeah.
I did do the research and found that there have been some, but a lot of them were in probate court, some in state courts.
And has ACCG taken a position on this of the clerk's authority? Who's
I know
been?
GMA is here to speak in favor of the measure.
I bet they're for it.
I don't know that the ACCG has not reached out to me about it, but I do know that I have the support of. I've had several calls from judges across the state that have vocalized their support for the measure, and they're.
And I did not sign it. Could I ask one question?
Judge, come on up right here to the microphone.
Who would be, first of all, I'm not speaking on behalf of the Council of Superior Court judges, but as the chief judge in my circuit, I am in favor of this. Matter of fact, we've been trying to, hopefully something of this nature would be passed. My question is, who will be in charge of deciding how the money is to be used? Because that's extremely important. Is it going to be the county commissioner, the county clerk, the chief judge, and the judges, or a combination of all three?
Yeah, I think right now it would be maintained in the clerk's office. But
Correct.
But it has to be limited to the uses that we specified, so that it doesn't just get applied for some offset in some other way.
That's why I'm asking that question.
Yeah, I think that would be handled both jointly with the clerk and the chief judge who issues the order. Every jurisdiction is slightly different in terms of how they want to administer funds and how they work on in that context. So I didn't get into that prescriptions because I wanted to let the chief judges have control over that.
This code section, I'm looking at, Judge, is 15:1-3, says the powers of courts generally. Every court has power to : and then we have this list of 7 things, and you'd add it on at the end. So my best thought would be that since this is the power of what the court has to do, the order instituting this, you would have the ability to
decide how it would be.
I would think so, yeah, because it's the general code section 15:1-3 is powers of the court generally, and every court has a power.
That's
Boom,
why we
issue an
did
order.
that code section.
Yeah.
And in criminal cases, going back to what Representative Oliver is stating, I'm assuming that it would be the same way. Let's say I have an indictment with 67 counts. We only put it on 1 count. Am I assuming that correctly?
Line 19 says a surcharge to each conviction.
Because I don't have a copy of the one that you're going by, and that's so I was trying to determine to make
Yeah,
sure
there you
that
go.
it's not. Okay.
May I add one final?
Ms. Oliver, go ahead.
One final comment. I know that Chief Justice Melton has spent a lot of time on this. I wish somebody would talk to me generally about a statewide application of what this has cost since we've imposed the fees, since what has been the cost since we've gone to uniform emailing, e-filing. Sort of a big picture of this analysis. I don't know whether this bill came from the big picture people or whether it came from the Henry County cyberware people or
It didn't come from big picture. It came from me and
the cyberware problem.
trying to solve a technology issue that is
Bigger
the
and
entire
bigger
system
every day.
needs to be separately managed and maintained so that when one part's not hit, doesn't shut down everybody else. But I do understand. My desire is not for there to be a $10 assessment on each conviction.
Right.
So I'm with you in that sentiment. I was simply trying to catch it on the front end, or where logically would follow in a criminal action. So I'm open to changes that minimize that exposure and gets back to that core, that core period filing. We're accessing the system. We want to utilize the system. We want our case protected, the technology to protect it. So how do we make it narrow? That's my goal. If you could help me, I'm happy to entertain those.
Mr. Walensky?
Two more things.
Thank you, Judge.
Based on my law firm, I don't think, unless we're talking about servers, I mean, really with what it sounds like is you want either, usually it's a large server on property, and then you have a cloud that's backing up this information. And that way, if the server gets hit, the cloud is doing it. And so I think we need, if we want to be really specific, I think we need to talk to an IT person about lines 31 and down, because I think we're more worried about cloud backup, which would be a monthly fee, and not hardware and software purchases.
Well, the cloud service would be a software purchase. I mean, that's weird.
But I would hope they have servers now. And then going back to line 22, I would just, I would, if it went forward, I would ask that defendants be involved in a civil action as well. Anyways, I've listed all my concerns at this time. Thank you, Chair.
What about line 36, the purchase of technical support services? Wouldn't the purchase of technical support services include cloud backup?
I would think so.
Well, the technical support are the people who are watching the cloud. The cloud is usually housed somewhere. I mean, the cloud is a made-up term that's really just huge servers at a separate location. I mean, it's actually, so that goes back to just, I think that area would need to be cleaned up, and I'm not an IT guy. I'm just a lawyer.
Well,
But you're a young lawyer.
Yes, sir. I got gray hairs now.
You young people are smart with this kind of stuff. My 18-year-old fixes my phone all the time. So
I think the terminology is broad enough to cover, because not everybody's going to be using cloud services. I mean, I think that there are jurisdictions that do. Mine does not.
Okay.
So that may be something that's used up in North Fulton or somewhere else, but not in Henry. And so it was our system, the hardware itself, that was effectively captured and inaccessible. So I think this is sufficiently broad enough to capture what we're looking at for a majority of circuits, but I'm happy to, I'm open to suggested language to move it forward, but I do think that these things are we shouldn't take lightly what happens to a judicial system when that is hijacked.
Yeah.
And that's what really is concerning me here, is that we're trying to implement something that makes it more defensive for our judiciary, to kind of thwart, fight back, insure against, and protect the assets that make up all of these claims and convictions and criminal proceedings that are going on. And so I would hope that we could fashion in a manner to move the bill forward, for that endeavor.
Yeah. Representative Lewinsky, what if line 36 said the purchase of technical support services and technologies?
Well, Chair, I guess, and I'm 100% with you. There's nothing more important these days than protecting our judicial system and everybody, every business involved with protection. This isn't about that, and I commend the efforts, and I think it's something we should work on. By adding more to that section, that loosens where this money can be used when it's for a specific cause. So that's my concern. My concerns, my final, and I understand the importance, and we need to look into it, but we won $250 filing fee when we do e-filing now for most of our filings. Where's all of that money going? I think, each lines 19 through 24 have issues, and then the broadness. So I just have concerns, and in no way do I mean to halter the bill. I think this is something we definitely need to focus on. This is just my first read, Chair.
I'm trying to remember that question. You've asked it twice now. Representative Oliver, when we did the $250 filing fee, when we did that southeastern state research to see how we compare, and we found that we were much lower, that was to help balance the state budget, wasn't it? You remember that?
I don't remember that
You
specific.
shaking your head, Judge Weaver? So I think that $250 goes to the budget that you and I vote on. It's $125.
There's Deborah.
Miss Nesbitt. Yeah. So that 125 goes to the state of Georgia?
Yes, sir. Yes.
Yeah. And the 50 used to go to the state of Georgia, and it was raised to 125. Now that, no? Come on up, Miss Nesbitt.
I was sitting behind the pole, y'all sat down.
Please introduce yourself and help us shed some light on the question that Representative Linsky has asked twice now.
Okay, Deborah Nesbitt with ACCG, and we haven't officially taken a position on the bill yet. I do know that many of these local bills have dropped over the last few years to add these fees. And so I think what he's trying to do is afford that availability to everybody. So basically, the base filing fee in Superior Court is $58. That's what goes to the local governing authority. And then all of the add-ons start attaching. The 125 judicial operations, indigent defense fee, crime victims fee, retirement fees. And so when you come up with the filing fee of $250, it really depends on what level of court you're in and, you know, which fees are attaching, whether it's a civil filing or if it's a criminal proceeding. We have a whole very complex chart on that.
Thank
Mr.
you, Chairman.
Walensky?
Thank you, Your Honor.
No, I'm not an honor. I'm just Deborah Nesbitt with ACCG.
May I call you Your Honor today?
You can. You may.
Would you think the technology fee we're looking at today would fall under judicial operations?
No, the Judicial Operations Fund, that $125 they're talking about was a new surcharge that was created back during the budget when we were having, I think it was 2008 or 2009. We did a whole study on court fees at ACCG, and none of them had been increased since the 1950s. And so we came forth with legislation to increase them based on the consumer index price increases. All we really got were increases in probate court fees. The state then instituted that $125 Judicial Operations Fund that is put on all Superior Court cases. And then in state court, the local county keeps 50 and 75 goes up to the state for the Judicial Operations Fund. We just argued that we fully fund state courts. The state doesn't give us any money for the operation of the state court. So why should we send a portion of the filing fee up? We didn't get very far with that, as you can see. And they have collected it all these years. So that goes up into the state general fund, and we don't know what it's used for.
So for our court system, where does the money come from to fund the computer system and technology used?
The counties.
Comes from the counties?
Yes.
Taxes?
Yes.
Okay.
Property taxes.
All right, any other questions of Ms. Nesbitt?
Thank you, Chair.
As always, you are a wealth of information, and we appreciate you.
Thank you.
Thank you. Okay, do we have anyone? I don't think we have anyone signed up to speak to House Bill 1078. Chairman Welch, you want to make comments before we do anything else?
Yeah, let me, if it's all right with the committee, what I'll do is I'll just try to work a little bit on that language that Representative Lewinsky has raised with me, and also some concerns that Mayor Margaret and Mr. Wilson have also raised on this end, and see if I can get a little bit tighter version back, if that's all right with the committee.
And somebody might know how many counties already impose this, how much they're in their.
Ms. Nesbitt, do you have any idea?
I'm not sure, but I think there's probably about 10.
Not many.
It wasn't.
The AOC would probably.
I knew of 5.
Is AOC here?
How many have technology today?
We don't formally track that, so we can't really speak to the numbers. So we watch the local legislation, but it is done by local legislation.
Okay. All right. All righty. Well, then we will hold on House Bill 1078 and move to House Bill 484. Mr. Welch?
Thank you, Mr. Chairman. This measure here is a substitute. The subcommittee reported out with a favorable recommendation substitute to HB 484 LC number 412473S. I've just asked for the committee to hear it. I'll go through it very quickly. Before this, the first iteration of this measure touched on issues that dealt in the area of evidence, and we, through 3 different hearings, we worked through this measure to remove the evidentiary elements of it, making it admissible medical funding. Medical funding is effectively a stopgap measure that exists in the marketplace for those that are underinsured, or I mean, it can be for anyone, but typically associated with those that are underinsured or do not have medical insurance. And as a result, what happens is that the medical treatment is provided to that individual. The account or the liens are then sold to a funding provider. The funding provider is a private entity that is banking on a settlement of the case or a jury finding the case that awards them more in terms of special damages in excess of the cost to have purchased the lien or the account. And so there's a delta between the final award of damages and the cost incurred by the medical company. And the medical company is paying the doctor, maybe doctor or whoever's providing medical attention, providing them at a discounted rate typically, and that discounted rate then is the sales price for the lien or the account, and this measure would allow for that to be discoverable, that information to be discoverable during the course of the litigation, so that the parties can fully understand the cost incurred and the treatment provided, and assess that for what it may be worth in the settlement proceedings, and or should it be admissible as ruled by a judge, then it could be determined to be relevant for aspects of bias when the medical professionals testify. That's the general statements of it. Then also there is an element of this that goes to lines 49 through the end, that goes through and prohibits what medical funders are not authorized to do in the state of Georgia in terms of incentivizing payoffs or commissions, referral fees, etc., to encourage the use of medical funding over their insurance, to go after the individual on a personal basis for debt collection should the outcome of the litigation be such that there was no award or the award was lower than expected. And so in trying to protect the customer, I guess really the client in the process, ensuring that they're not exposed to a contract that they may have signed off on under duress, try to protect them as well. So it's a consumer-friendly measure, but it's also helps to get at the information that is kind of in this sub-market, if you will, of medical funding. That's the nature of the bill. I think there is I know there's some folks here that have come to testify about that, Mr. Chairman, to provide more information and provide you with some actual examples of some contracts and activities that are very egregious and that will shock the conscience, I believe, and that's where this measure comes from. And that is to be clear and to be fair to everybody here. We understand that there are good actors in this arena of medical funding, and then there are bad actors. But at this point in time, it is impossible to distinguish. It's not impossible, but it's difficult for a customer to distinguish between the two. And the folks that have testified willingly have traveled great distance from Chicago, from around the metropolitan Atlanta area, and elsewhere, that have testified on behalf of the medical funding companies, have done so with a sense that that yes, there are bad apples, bad actors, and that there should be some regulatory oversight relevant to those bad actors. But they've also raised the concern that the discovery element of this would undermine their market, undermine the business, make it less likely that they can be successful in the business. We've added some provisions about keeping the records under seal, the contracts under seal at lines 41 and 42, so that there won't be competitive natures between the funding providers, but they have still expressed concern that the overall measure might shut down medical funding in the state of Georgia. So I'm just trying to share with you what testimony we've heard in the subcommittee. I don't want it to be not everyone is on the subcommittee and has heard these debates, but I wanted to try to elucidate that for everyone on the full committee. But there are members that would like to speak on the, or not members, but there are folks that would like to speak on the bill, if that's possible, Mr. Chairman.
Okay, I think the questions, though, for you, the author, would be, let's see, Mr. Wilson?
Yes, sir. I have a question about specific language that is mentioned in twice in two different paragraphs here. Looks like starting at line 40 and then starting again at line 46, the language, and the tortfeasor and the insurance carrier shall utilize such agreement only in connection with the purpose or purposes for such disclosure. What does that mean?
That in the disclosure of the discovery, that for the purposes of disclosure, they're in request made by the insurance carrier or the tortfeasor of the medical provider, the funding provider, that those would be agreements that would be brought forth through the discovery process. And so that may not be as well worded as it ought to be, but that's the intent.
Okay, so the intent, I'm trying to make sure I understand your intent here, is that they would only be able to use the agreement for the purposes of whatever claim or action is involved.
Whatever insurance claim has been filed.
Okay.
So, and that's to guard against them being utilized in a, because we have the collateral source rule, and we're trying to guard against that being construed here in a way that would affect the collateral source rule. So,
Chairman, what you mentioned a couple of times, people may want to testify. What I should have asked you is before you take questions, is there someone you want to come up to testify on the bill to add to the discussion before the committee members ask you questions?
yes, Zachary, you had testified before, and I thought it had some compelling information.
Come
as
on
a,
up
as
and have a seat and
defense litigant.
introduce yourself to us, and we'd be happy to hear from you.
My name's Zach Matthews. I'm a partner in McMickle, Curry & Branch in Alpharetta. We do both plaintiffs and defense work, but I primarily handle catastrophic defense work. I have a presentation, if we could drop the slideshow machine. Turn on the overhead.
This technology. We had a fee for that.
As a rule, when I try cases, I bring everything on paper because I don't trust technology, so hopefully this will work.
Hey, John, do you have anybody who wants to?
Okay. While this is warming up, I just want to say for the purposes of the committee, the same thing I told the subcommittee, we have redacted all publicly identifiable information here. So this does come from discovery in a number of different lawsuits, I think about a dozen cases actually. But we've been real careful to take anything out that would identify individuals or the specifics of their detailed arrangements. I also want to go ahead and just agree that we're not here today to criticize the medical funding industry as a whole or say that the entire industry is purposeless. It does serve a public purpose. It can help people access medical care, and we don't dispute that. What we've experienced is, quite frankly, some instances of abuse that I wanted to share. Not sure what I need to do to get this on the screen here. Maybe plug it in. Yeah.
And then, Mr. Chairman, there is a gentleman from the medical funding industry that's here as well. See, we need technology fees. See,
Not purport to be.
We could have
A
already had someone do
technologist,
this.
that's right.
I just was going to tell you to turn it off and turn it back on. And
Yeah,
that's what I usually
that's
do.
what my IT department usually says too.
I have not done anything with the Senate on this, so I don't know what they're doing. I know they have a medical funding language, and it's probably similar to this.
There we go. Okay. This bill, as we see it, and when I say we, I mean generally speaking, the defense bar, is primarily about transparency. It's about getting disclosure of information basically to our judges. So our judges have the benefit of enough information to make a good call about what should and should not be allowed in the trial of a case. Most judges are probably familiar with the interplay in civil actions of medical funding with issues of bias, intent, and motive. And the 11th Circuit has recently ruled on this quite specifically, and so has our Court of Appeals. Bias, intent, and motive in the context of a doctor who has accepted a lien on the outcome of the case can mean that the doctor is motivated to testify a certain way. And the idea is to let the judge make a call about whether that's a real thing in this case or not. And it changes case to case. It's not always a circumstance that we deal with. What we have seen is that the typical funding model, which is that someone comes along and buys the bill after someone has treated and buys it for a discount in order to hopefully collect the full bill eventually and thereby make a profit, is not the only means by which the medical funding community operates. What you see here is an example from a particular clinic in the metro Atlanta area of an agreement whereby the plaintiff has waived their personal medical insurance when they signed up to treat with this particular doctor. And you'll note that the attorney's name is blacked out, but the attorney is asked to sign off on this. So the plaintiff's lawyer is agreeing and presumably counseling his client to go ahead and take treatment from a doctor on a lien where medical insurance was available, and thereby they would have gotten lower prices. So they've essentially signed up for bigger prices, presumably in order to make the damages larger, so that when those damages are eventually presented to the jury, they will be as large as possible. I think this is important for the very few non-lawyers, it looks like, on this committee, but those who've never practiced civil law. Kind of rule of thumb in the world of defense. Jurors are asked to pay based on people's personal injuries. When they get back in there in that jury room and they have to debate how much money to give, they really don't often have very many hard figures. How much is pain and suffering worth? So what we have seen over a couple hundred years of jurisprudence is that the jurors will really fixate on the amount of the medical specials or the medical damages as their baseline, and then they use that as a multiplier. Typically in the jury box or in the jury room, somebody will say, well, you know, if this person has $100,000 in meds, we need to pay that back. They're going to have to pay that bill. And then they think about it and say, well, how much is pain and suffering worth? Well, let's give them the same thing again. That's 2 times. And then some smart juror says, well, the plaintiff's lawyer gets paid. He's going to take some of this. And they say, that's right. Let's give them 3 times their medical expenses, 3 times the specials. And that way we give a nice round figure that makes sense based on the presentation of evidence that they are hearing. If the medical figure goes up, obviously every dollar you add to that as a multiplier is multiplied by 3 times. And we typically, especially in catastrophic work, and I see some of my catastrophic colleagues on the other side here, we don't hear 3 times specials as a baseline anymore. Most of the time the pitch is 5 or 6 times specials in a high-loss trucking case or a bad negligent security shooting matter because jurors have become accustomed to giving bigger numbers. So when you see these types of agreements where they're opting out of their medical insurance, that has a very fundamental effect on how the overall case could go in terms of value. At the subcommittee hearing, we had one of these to show, and I wanted to address any concerns that this was a limited thing. Here are 2 more. This is an ongoing practice that's happening apparently in every single case that comes into this clinic. This clinic treats about 2,000 patients a year in Atlanta who have lawsuits. So this is a very large number of people. The same clinic is not allowing, basically selling its bill at the end of a treatment period to a funding provider in a factoring model. Instead, they are working with the funder to help cover their overhead. And what we see here is that they are binding themselves, the client in this contract right here is actually the doctor's medical clinic. They're binding themselves to use their best efforts to settle each account for as high an amount as possible. So in other words, the doctor is contractually obligated to try to help the funding company recover as much as it possibly can. You have a fraud guarantee agreement that comes with that, and one of the triggering events is the fraud or willful misconduct committed by the borrower. That fraud guarantee agreement is actually signed specifically by the owner of this clinic, who is a physician in Atlanta. They understand who they are getting in bed with, and they understand the optics of bias, intent, and motive, and the fact that all of this funding money that is washing around can create an incentive that can lead to fraud. And I'm not accusing anyone of fraud, but I'm just saying that this contract presupposes that fraud could become an issue.
Hold on a second.
Yes, sir.
Say all that again now. Tell me what I'm looking at and
Yep.
why it's relevant.
This is a contract between a physician who is
Right.
going to treat on a lien and a funding provider who is going to help him offset his overhead. They are actually loaning him money along the way to cover his overhead rather than buying the note at the end of the treatment. So they remained joint venturers. They remained in partnership with each other. And as part and parcel of that partnership, the doctor, who is eventually going to testify in favor of this plaintiff's recovery, is binding himself contractually to make his best efforts to settle each account for as high an amount as possible. The doctor's contractually obligating himself into a certain posture. He basically has to support the plaintiff's claim, because if he doesn't, not only will he not get any more referrals, but he also will have violated the contract that he signed. And we see certain examples of that. That's what this next slide was. This is also from the same contract. Again, the client here is the doctor. Shall provide any and all required support reasonably requested by the funder, including depositions, live testimony in court, etc., in order to prove the financed account receivables due. So when a judge is asking questions about whether it demonstrates bias, intent, and motive, here it is in black and white. The doctor has agreed that he's going to take one side. He's going to evaluate this person's treatment and this person's claims with an eye toward helping the funder recover as much as possible. And that means he's going to testify that the incident caused the need for treatment. Causation opinions are very important in this world because the jurors have to hear from the doctor, yeah, this stuff, this bill that's being presented to you was caused by this accident, not something else. We also see that the doctor is obligated to provide the funder with, quote, detailed reports on a monthly basis, or as the funder may reasonably require, to determine the continued collectability of the financed accounts receivable. I want to encourage the committee to keep this in mind, because what this does is it creates an incentive for the doctor to gather information so that he can present it to the funder. If he does not have the information to tell them about the lawsuit, he can't keep them up to date. So he's got to go get it from somebody. Just the last snippet is just to note that these contracts contemplate, they use terminology like we do in the litigation world. Slip and fall cases is not a medical term. That's a term in our world. And these funding contracts contemplate that kind of a thing. This is the testimony from the COO of this clinic explaining what that contract was. That company is a funding company that we use from time to time to help with our cash flow purposes, okay? Is that tied to specific patients? Groups of patients. All right, and I'm sorry to be obtuse. I'm just not following you. When you say cash flow purposes, the answer is they would fund us money and then we would pay them back later. I said, I see. He said, based on the fact that we have a lien. So this is not the model where they're selling the whole note. This is actually like an ongoing relationship that goes along for the ride. And those are the tranches of cases that they're selling. And the testimony in this case is that this is one set of 10 cases out of 407 that were sold to this funder. And if you do the math on this, you see that we have 10 cases here. The billed charges are the amounts that were billed to the plaintiffs in that case. The cost is the amount that this loan was for, 25% of the billed charges. If you take that figure, $1.4 million, and multiply it by all 407 cases that we're aware exist, the total is about $54 million in lawsuits that have been financed through this funding company with just one clinic. And there are several clinics in the Atlanta market and throughout the state who operate on this same model. Those blackouts are mine. The lists of plaintiffs' lawyers on these cases are actually in the original document. And they're names that we see over and over again in multiple cases. So there's a continuous relationship and a referral relationship. And the idea of getting more work is not a hypothetical, it's a certainty. This was my follow-up questioning about the implications of this. So again, I asked the COO, okay, so if a patient is an ordinary individual who has a job as a retail salesperson, that was who this was in this case, and this clinic issues treatment that totals hundreds of thousands of dollars. Her treatment was $467,000 in this case. In this particular case, it's $400. At the time, it was a little lower. Okay, we can agree it's not reasonable to expect a retail salesperson to ever repay a $400,000 medical treatment unless she recovers in a lawsuit, right? And the answer from the clinic was, I don't know if I can agree to that. I mean, I don't know what their situation is. I said, does this clinic pursue people into bankruptcy over medical payments? He says, I believe we have. Yeah. Now I want to focus on that. This clinic has to occasionally make an example of somebody. Because if they don't ever make their note good, if they don't ever pursue someone into bankruptcy, they're conceding, for purposes of the judge's analysis, that these bills are all fictional to begin with. So the outcome is, just watch the process. The plaintiff comes in, the plaintiff gets counseled not to use their medical insurance. They sign up for larger bills that are going to help support the lawsuit than they would have to be charged if they had medical insurance and used it. If their case isn't good or they don't win their case for things they can't control, stuff may develop along the way, some of those folks are going to get hounded into bankruptcy with higher charges than they would ordinarily have had because they agreed to get on this model. Now, why would the clinic do that? Why would you do that to your patients? And the answer is because you make a lot more money with the amount of litigation funding that's washing around right now than you would if you just treated on insurance. One of the things that we've been trying to get discovery on is exactly how much. The 407 entry spreadsheet would have allowed us to calculate the specific percentage of recovery that this particular clinic has. But instead of letting that case get decided by the court, they settled it this week for less than a third of their meds because they really didn't want that information to come out. And I think that's very indicative of what we are seeing in this abusive side of this industry. This is the level of cooperation that is required, again, because they have to provide this information to the funders. This is a letter that was accidentally dropped off in my office with a box of donuts. The clinic says, this is a letter that they thought they were sending to their partners, to our valued attorney business associates. The personal injury department, the doctor's office has a personal injury department, will be asking for the following information. Case status every 30 to 60 days. We do not make this information a part of the patient's clinical record. Can't have a more clear-cut idea that they're going to split their file. The federal court agreed with that. The federal court ordered that all this material be produced primarily because of that statement. They admitted that they're hiding things. This is what the doctor's EMR suite looks like, electronic medical record software. At the bottom, you see medical decision-making being conditioned upon the amount of insurance limits. Limits $1 million sufficient for stem cell treatment. Looking up there, you can see 25% current, 15% after settlement. That's the funded amount. This is a funded case. Another example, limits issue. This person has an SX surgery in medical speak. Surgery recommendation, decompression of L4-5 with possible Coflex, estimation approximately $167,000. So that's a surgical procedure that has been recommended for this patient. But they have a limits issue. I think in this case they weren't aware of what the limit would be, and they had only $100,000 that was on file. So they called attorney, emailed attorney regarding direction on limits issue. In other words, they're waiting for a thumbs up from the attorney as to whether or not to provide medical treatment. They're ceding medical decision-making authority to a non-doctor based on stuff that has nothing to do with the need for treatment. A little worse. Per attorney, patient was involved in another collision on March 22nd. Liability is being disputed. Continue treating him for the current case. In other words, split your file. This guy's had another accident, but liability is being disputed in the new one. In the one that you originally had, liability was guaranteed. Continue treating him for the current case. Don't put anything on that new file. Here's another one. Called attorney, spoke with the attorney, who advised that they do not want the patient to have the surgery. Advised the patient, that's who that second blackout is, that attorney has canceled surgery. Emailed all to involved that surgery is canceled. Called the patient to advise, we have to cancel the surgery due to limits. Advised the patient to contact the attorney for direction. Again, the doctor is allowing the lawyer to make a decision about whether to proceed based on how the case is going, insurance availability, and they say limits, but there's a broader concept there. It's not just the amount of the limit that may be available, it's also the collectability. So if the case is not going well and you get a thumbs down, you're going to cut that patient loose because you may not collect at the end of the case and it's no longer financially viable. Completely different clinic. Surgery got moved to Monday, 1:15, and I left blank a message about the surgery fees and the new date of service being Monday. That's the paralegal. Spoke with the paralegal, and she said, attorney said we are good to go. This is in the doctor's office's notes. Attorney said we are good to go, and then they actually copied the email in. I have updated Mr. Attorney, and he has given the okay to proceed. Thank you. So they don't do anything until the attorney says to do it in these cases. This is an intake form. This is a doctor's office's intake form. Slip and fall property liability referral information form. One of the things they ask about is the presence or absence of cameras before providing medical treatment. Then case limits, including insurance company and claim number. The block at the bottom is the clinic name. It does require all slip and fall property liability cases to be submitted for review prior to scheduling. Please allow between 2 to 4 business days for review of all liability cases and attach any reports, incident reports, etc., to this referral. There was a question raised in the sub about whether the attorneys are signing off on this. Yes, they are. This is just one of a multitude of examples of waivers and acknowledgement of medical services on a lien. This is similar to a letter of protection. The attorneys are actually immediately being required to say, yes, we will protect the doctor's lien before any of this begins. So the attorneys know the entire time. They're required to know. It's part of the process. This is particularly egregious, and I do want to address this. This is from a funding company contract. Client assigns all of client's interest in and to the legal claim to this funding company. And this funding company hereby accepts the security interest from client on the terms and conditions provided in this funding agreement. That provision of this contract is almost certainly void for public policy. OCGA 44-12-24 says you can't transfer an interest in a personal injury suit to somebody else. That's what that is. That's an assignment. Most likely that funding company would be a real party in interest. The court would be entitled to determine whether it's a real party in interest. And in fact, under our code, the case is not supposed to go forward if a real party in interest is not part of the case. So for the judge to have the wool pulled over his eyes as to who is really in control of this claim and who owns it outright at this point. Like, fee simple, here you go. He's got to know, she's got to know. What does the contract say? This is an irrevocable letter of direction. The funding companies commonly extract these from the plaintiffs when they issue funding. And this happens both in the medical context and also in the direct funding context, where they pay money to the plaintiff, who then turns around and pays the doctor with that money. Be advised, I have sold a portion of the proceeds of my legal claim equal to this ownership amount to this funding company. This letter is addressed to the plaintiff's lawyer. It's written by the funding company, but it's addressed from the client to his own lawyer, telling the lawyer what he can do and can't do, requiring the lawyer to protect the funding company's interest first. So the funding company gets paid before anybody gets paid. Now, whether they really do it that way, I don't know. But at least on paper, if a plaintiff has a compromise settlement and they funded part of the claim, first priority goes to the funding company. That would be okay if the funded amount was still somewhat rational. But what happens is this. Here's a low amount of funding, relatively small case. They funded $2,651. Over the course of 36 months, the payoff went to $9,467. That's 275%. The funding companies know, because they're sophisticated, how long litigation takes. 2 years, 2.5. I've got cases that are 7 or 8 years old. The average client does not know that. And if their lawyer's straight with them, he'll tell them, hey, look, you know, this thing may go to the end of that chart. Usually they're capped because they don't want to get into a usury posture. But, you know, is a plaintiff going to make an educated decision when they need that money right now? They're in a bad position, and they're easy prey. That's a small case. Here's a bigger one. This lady borrowed $53,000 at a 45% interest rate. She ended up having to pay $167,000 back a year. Let's see. So this was March 28th, 2019. That was a year ago. That case settled this week for $150,000. So that lady ended up having to give, presumably, her entire settlement back to the funding company on its interest rate at a 45% interest rate. I'm not trying to get on my high horse, but some of this stuff is just wrong. And part of what we see here is abuse of the system that is created, frankly, just by the availability of the kind of money that's washing around. Not every funding company is bad. Not every funding company is crooked. Certainly not every doctor is crooked. And we don't mean to suggest that. But there are bad actors out there. Discovery lets the defense understand these relationships and lets the court understand that. At the end of the day, the defense is it's the instrument of the court in this circumstance, because that's the party that's got the incentive to go do the discovery to find out what this stuff is and then come present it to the judge. The plaintiff is not going to present this to the judge because unless they find themselves in a bad faith situation down the line where they're trying to sue the funding company for taking advantage of them, but that basically never happens. These circumstances are a direct result of basically a lack of transparency. If there was more transparency, I don't think these types of contracts would exist. That's what this bill does. It promotes transparency, doesn't make any decisions on behalf of the court. The judge is still in control. The judge can see all of this stuff and say, you know what, I don't think it's relevant. And that's fine. But at least by that point, someone has had some judicial review of this. And that is going to both protect plaintiffs and also protect defendants from being taken advantage of in a system that inflates a bill unfairly.
Mr. Matthews, you began, I believe, your testimony by saying that there are good actors and bad actors in this industry, and you've just given examples of what appears to be pretty bad actors and what they're doing. You know, you may not be able to quantify this, but when we look at problems, we try to figure out how big they are.
Sure.
And so I'm trying to figure out how big this problem is. Are we talking about, 90% of the companies are not doing this and 10% are? Or another way to quantify it would be that the companies that are doing this bad work are handling 50% of what goes on out there versus 50% are by other companies that are doing it right. Any way to, in your mind, to quantify the extent of this problem?
The problem with being a defense lawyer is you're automatically filtered. Every single case that I see that has funding has these types of acts in it. Every single case. One of the clinics that one of their slides was up here, just one. Their doctors testified he treats 2,000 patients a year who have lawsuits. So this is not a small problem. This is a multi-million-dollar, thousands of cases, large problem that is affecting Georgia jurisprudence. And we think it's affecting the overall circumstances of doing business in Georgia because the funding creates incentives to drive up damages in a way that put, frankly, a chilling effect on wanting to do business here. That's one of the reasons that we're involved. We see the funding as a primary issue and why verdict values are starting to increase in a very big way. They have very little to do with a nuclear verdict or a very big case, big product liability case, but they have a lot to do with the overall value of the volume of small claims that we see. So if every small claim that started out as an advertisement on the side of a bus used to be 5,000 and it's now 25,000, that becomes a big deal. And we think the funding companies have a very, very big role in that.
Another attempt to quantify the magnitude of the issue that we're dealing here with is what have other states done? Are you familiar with what other states and other 49 states have done to try to address this problem, if anything?
There's different ways to deal with this issue, and some of them hit it with a hammer. And I don't think Georgia as a state is prepared to take those steps. Most notably in California, for example, which is, Ninth Circuit, very different from Georgia in most respects. They have a billed versus paid model. So the jury gets to find out at the damages presentation at the trial of the case, they find out both the amount that was billed and the amount that was actually paid. That gets rid of all this stuff, because if you know exactly the amount that the doctor took, then you have a pretty good idea of what it's worth. Now, we still expect juries in certain circumstances where there's been funding to award more money to the plaintiff because they know they're in a bad spot. And that's, like I've said in the sub, that's worth a certain amount, a certain percentage, maybe 10, 15%, that would allow the funding companies who have altruistic goals of providing access to medicine to exist, to make a profit, in fact, to be highly profitable. But it clips the wings of the ones that are trying to charge 5-6 times what a reasonable and necessary medical expense would be in the state based on market averages, which is what we're seeing.
Mr. Welch, did you have any questions?
Well, a few comments. To hear that the state of California has done it where they're exposing both the billed amount and the amount paid is effectively what this does, but just through the discovery process, and then allows for our evidentiary rules to play in thereafter. And I think that provides a certain amount of protection against the evidence being equally as biased
That's right.
in favor of the insurance companies as and against the plaintiff. So I think that this strikes a good balance in that regard. But what it tells me further is that in that context, the medical funding industry in California hasn't shut down.
That's right.
So the apocalyptic scenarios that we've heard before about this ceasing to exist, this is an in-between step, and yet the medical funding companies still exist because the good ones make a reasonable profit in this, but not a 45% profit off of it, effectively getting close to a usury number. And to me, what grips me about this whole issue is that there is a in most cases a bona fide injured party who cannot work or is cut off from work to some extent, that is in a desperate situation to make ends meet and pay bills. And if that person is being taken advantage of in that situation, I mean, my heart goes out to the consumer of this, to the injured party, that this system, if not put in check, runs rampant and allows for unscrupulous actors to take full advantage of Georgians, not only those who are injured, but then in driving up those claims also impacts the rest of Georgians who pay insurance premiums. And that's a double hit in my book.
Mr. Lewinsky.
Thank you, Chair. Georgia's still the number one place for business, right?
I'm sorry?
Georgia's still the number one place for business.
Georgia was added to the list of judicial hellholes this year. It was number 6 on the list.
I think we got 5 or 6 years in a row. And you said multiple times that we have that the consumer's taken advantage of. So have you ever complained to the medical board about this doctor?
Have I personally ever complained to the medical board?
Have there been any complaints to the medical board about the insinuation that it sounds like he's outside the standard of care?
He was sued for malpractice for leaving a needle in a woman's spine and making her a quad last week.
Okay. So I think the medical board may take care of a doctor who's a bad actor, number one. So. And then the implication that the attorney is when we have this woman who's led the wrong way, and then she gets totally, can I say screwed in here? Okay.
She gets totally
taken advantage of.
Yeah.
Understood.
That would be a complaint to the state bar for malpractice. So there's another gauge in there to watch them. It would be malpractice of an attorney to lead a client in the wrong direction and give bad guidance that leaves them $100,000 in debt.
I don't mean to cut you off, but I'm not insinuating that the plaintiff's lawyers are giving her bad advice. I think they're disclosing what this looks like. I just don't think the plaintiffs themselves have a real clear picture of how likely it is that it's really going to take that long to get their money. Most plaintiffs' lawyers know clients really think they're going to get paid like tomorrow most of the time, and it takes a lot of talking to them to help them understand how long the process can be. They don't always necessarily listen to good advice.
Yeah, good plaintiff attorneys do that, and they're very good with their clients, like myself. Georgia has always been very strong and open to that anybody can make a contract with anybody. Like, I started out in collection bankruptcy, and I've seen title pawn loans for 300% interest. So Georgia's very strong in allowing that business to work how it is. Is that right?
As to the usury issue, you're correct. The Supreme Court decided a case called Ruth versus Cherokee Funding a couple of years ago. It was taken up by Darren Somerville, who's a prominent member of the plaintiff's bar.
Great attorney.
He's a great attorney. And what the court said was that 350% is not de facto usurious. However, they did note that these types of arrangements might violate 44-12-24, which is the assignment of a right of action in another case. So those are issues that are being litigated.
Yeah. But Georgia's been always strong on the fact that anybody can make a contract with anybody. We're very strong on that.
Okay.
And then OCGA 24-921 also has a remedy for defense attorneys where the plaintiff must prove that the medical bills in her case are reasonable and necessary. And that doesn't look reasonable. So in your cases, do you bring up this code section and go after them for the medical bills not being reasonable?
Actually, I think the statute says that the plaintiff does not have to prove reasonableness and necessity in order to put her bills into evidence. But the answer is yes. We certainly would confront an unreasonable presentation of bills. A lot of times we'll do that with expert testimony that would compare it to the market averages. And that would be like, for example, I'm not forgetting the name of the company. Acumed, thank you. Acumed or a similar expert who could say, here's how much the market charges. But the problem with that is that the plaintiff can look the jury in the eye and say, okay, apparently I got taken advantage of here, but I've still got to pay this bill back. That's a really serious problem.
And, well, the judge can rule that the bill wasn't reasonable and lower the amount.
No, sir, I've never seen that happen.
But under the code section, they can. They can, the plaintiff attorney is only to make a claim for the reasonable amount of the medical bill.
I think you're arguing that the court could exclude evidence in limine. Yes, the court could grant a motion in limine to say this doesn't come into evidence, but a court is not going to rule before a trial that a bill is high and lower it for purposes of the jury's determination. I've never seen that happen. I don't think that's within the court's power.
Mr. Bruce?
Let me preface this. I'm not a lawyer.
Yes, sir.
And Mr. Chairman, you kind of stole my opening line in that you started out your comments, by saying that not all companies were bad. But the reality is that those that are bad are making it bad for everybody.
That's right.
And what ends up as a consumer, and as I sit here, no offense, my friend, but it sounds like the lawyers want to defend, the practice of which you are talking against here.
Not this lawyer.
Okay, not all lawyers, but I'm just saying, I'm just going by what I heard him say. So my question, as you look at the documents you had up there, the average patient, they already are sick, they're already injured, they already have issues. They ain't reading that stuff.
That's probably right.
Yeah, and they're counting on somebody to help them through the process, lawyer. If they have one. Some of them probably don't have a lawyer. They've signed documents, don't have a lawyer. So I guess that was my comment. But my question is, I heard the remedies that he was talking about that you have against the lawyer. You can go to the bar association or whatever. But the average person out there doesn't have a clue about all the things that he just said. Is that an accurate statement?
Yes, sir. I think the only way the average person is going to, figure out what they weren't told if they weren't informed properly by either the judge or the doctor or the lawyer that they hired would just be to hire a different lawyer. But that only happens if you get to a malpractice situation, which is not common. Most lawyers do not get sued for malpractice. And I don't think, again, the plaintiff's lawyers that have these plaintiff's cases are committing malpractice. I just think these people are in a bind and they're acting on pretty much wishful thinking, hoping to get paid quick and easy, and that's not how it typically works. And then when they get on a litigation train, particularly where a doctor's recommending surgery, where the doctor's got an incentive, a financial incentive, and a referral incentive to keep the train going, man, that has to affect your judgment.
Okay,
and that's a problem.
One last thing, and then I'm going to pass it on. But I guess the big concern I have is that I'm hearing in your testimony that non-medical people are making medical decisions, and if those decisions cause the death of someone, who's liable then?
We've wondered that. I think there would be a big litigation if that circumstance were to come up.
Judge Goggins?
My question is about opting out. Tell me about the opting out of the insurance.
Yes, sir. Apparently, it's a standard practice. This is coming in every single packet that we're getting from this particular clinic, and I pulled 3 of them because I just wanted to show it's not one time. You can see what the form says right here. I will be using only this letter of protection to satisfy my medical expenses with the providers listed above. I have chosen to opt out of using any commercial health insurance coverage I may have available. They also opt out of automobile med pay. What does this mean? The full cost of my medical services will be held as a lien against any and all settlements paid to me. Opting out means I have chosen not to use any commercial health insurance coverage. The typical doctor works on a fee schedule. The fee schedule is usually so big. My brother's a doctor. They call it self-pay. Self-pay is what someone would pay if they came in off the street with no insurance, put their money down and said, do what you're going to do. Give me a surgery. Give me tooth removal, whatever it is. Medical insurance companies negotiate with healthcare providers beforehand to get lower rates. And that bill that is sent to those healthcare providers is adjusted based on those contracts for what the provider will pay. So at Blue Cross Blue Shield, if you go to the same doctor, you're going to get a better deal on the treatment you receive than someone who gets self-pay. A plaintiff who comes in with the benefit of Blue Cross Blue Shield or whatever it may happen to be and opts out of using that insurance, and we would argue eventually that this is a problem with their duty to mitigate. They are accepting higher damages. They are agreeing to be charged more. Ultimately, and you see right here they say that, it's so that this charge can ultimately be presented to the jury as part of the lien. The doctor's bill is simply bigger if the person agrees not to use their medical insurance.
How is that legal? I mean, how can you opt out of your insurance? I don't get it. I mean, you pay insurance all your life.
Right.
And then that needs to be addressed. I don't think you should be able to opt out of your insurance to make the settlement look higher so that you get a bigger award from a jury. I mean, that just, I don't get that.
The term shocks the conscience was used earlier. My mouth dropped the first time I saw one of these. I couldn't believe it. I still can't believe that they
So
operate
the
that way.
clinic counsels that person to opt out of their insurance to make the amount look higher so that they can get a bigger settlement from the jury.
And based on these forms, it appears the attorneys are also involved and are signing off on it. And I don't know how that
That's
can
just
happen.
wrong.
I don't understand that.
That's
I
wrong.
admit I don't understand that.
Thank you, Mr. Chairman. Thank you, Mr. Matthews, for this presentation. Again, I heard it previously, and I would wholeheartedly agree with Chairman Welch that this problem needs to be addressed, and it needs to be done so in a fair way. I think, especially given Judge Scoggins' question about insurance in particular, as well as some of the other concerns that have been expressed, I think that this is a bigger problem than the bill addresses, honestly. I really do. I think we can do this better. I sincerely do. And I think we can do so in a way that, particularly in lines 43 through 48, by doing this via discovery, I think we are potentially at least partially changing or eliminating the trade secrets law, because the medical funding company's their whole business model is based on that being their trade secret, how they do that. I do think that there are databases like Acumed. I do think there are other models in other states, as you mentioned in California. I think that we could do this in a way that would eliminate the bad actors, would eliminate the bad contracts. I think it's very important that we keep medical funding in place. Because being a 2-time cancer survivor, my parents could not afford all the bills that I had when I was very ill as a senior in high school. And there was not an option for medical funding at that time. And my parents worked morning, noon, and night, both of them, double shifts kind of thing, to be able to pay back my incredible medical bills. And even though my insurance, maxed out what it would pay. Mm-hmm. And so I think it serves a very important public policy purpose for medical funding companies to exist. I also think that it's important for medical funding companies to exist because physicians don't need to be in the business of being a bank. And under the old model, before there were medical funding companies, the physicians would just hold the lien, hoping to get paid, maybe not, but that would also bias them if they were treating that person that would bias them to treat them additionally, as you mentioned. And it would also color their testimony if they were called into court. So I think that the funding company also provides a means where the physician can be separated and from the treatment of that person in an objective way. Mm-hmm. That being said, I think it should be done in an ethical way. And of course, the charges should just only be usual and customary. My understanding is we would be the first in the nation to have a bill of this kind. I've done some research on this, and there's no other law like this in the United States. There are people in New York City that are watching this bill, believe it or not. And so I would just err on the side of caution. I would be happy to step forward and run a study committee on this issue because I think we need to fix it, but I don't think we need to rush this. I think we need to fix it right, and we need people to have a means to get medical treatment in an ethical way if they can't afford insurance or they are underinsured.
Yes, ma'am. I understand I understand what you're saying, and I agree with much of what you said. Let me just break it down into a couple of parts. With respect to your personal experience with cancer, I'm sorry to hear that. You most likely would not be able to access the medical funding system we're talking about today because unless your cancer was caused by someone else against whom you had a lawsuit, there are not medical funding companies that I'm aware of that would do business with you. They are interested in a profit. They are interested in making that profit through the lawsuit system.
But banks are in the business of making profits too, and there are plenty of factoring businesses that are around that essentially that's what they do. The title pawn business is a factoring business of sorts, and none of the risks that these companies undertake are expressed in this bill either, because they too take risk for people to get treatment, and whether that is unreasonable or not, I think that's for a jury and a judge to decide, but I think we can put guardrails around this and we could do some regulation that would shore it up, but would be fair and leave those companies in existence.
Agree with that too, and I think just to give you some context of why you're getting to see this stuff.
Mm-hmm.
This was a 2.5-year discovery battle. It involved crazy facts. The lawyer who was representing the clinic that I was up against killed his own mother and was disbarred in the course of this battle. We saw things through this that would never have come to light had the court not gone along with us in basically showing the court piece by piece, there is a problem here. And some of the stuff that we saw, like the attorney-directed treatment, I'm sure there are rebuttal arguments that can be made. Some of the things I think are less conscionable, like this, opting out of your medical insurance. I don't think anybody in this room thinks that's good. But for daylighting those issues, this would never have come to the light of day.
But
And
don't you think that we need a stronger insurance commissioner in the state of Georgia?
I've never seen the insurance commissioner get involved in anything in my world, so I don't know the answer to that question, ma'am. I'm not.
He doesn't really have power in Georgia like he should.
What I do know is this: the courts have power, and this is a small step. I mean, obviously we get this stuff anyway at my firm. We know ways to make this discoverable. This is a small step toward making this more broadly discoverable, so that other lawyers who maybe haven't seen the stuff we've seen can show this to courts and let the judges be the filter. You know, in the court system.
Oh, I agree. I agree with you. I just think we can do better than what we've got on the paper.
Okay.
Mr. Wilson.
My question is about once you get this information through discovery, you talked about then being able to bring it before the court.
Depending on what it shows.
So what do you do with this information once you get it?
Depends on what it shows. Certain cases, and we do this, you know, we kind of run the same playbook all the time. We get cases where the plaintiff has been injured, has gone to the doctor. Maybe there's funding involved, but the numbers are small. You know, the $2,500 loan instead of a $47,000 loan. In those circumstances, those don't rise to the level of creating a significant bias problem. And quite frankly, as a defense lawyer, it's not worth your time. You're not going to get any argumentative value out of that. When we see egregious stuff, yeah, we do. We bring it to the court's attention. One of the issues that we see, this gets into a little bit, this is the weeds, but doctors who are going to testify as treating physicians versus doctors who are going to testify as expert witnesses who must give a report in federal court, what they've got in their file matters. And if they've got a bunch of extraneous data that they've gathered from communications with the plaintiff's lawyer, pictures from the scene, they're going to fall into the expert witness disclosure guidelines, and they're not going to be able to masquerade as treating physicians. Unless the defense knows that that person has all that data, there's no way to force them to make those disclosures. So the data becomes very important to tell the courts who these people really are. This is not a treating physician. This is an expert who's going to give a causation opinion and who has a contingent financial interest in the outcome of the case, a lot like the plaintiff's lawyer. But the difference is the plaintiff's lawyer does not get to testify. He never takes the stand. He's known to be an advocate, so the jury understands his role. When a doctor is doing that, coming in a white coat and secretly being an advocate for the plaintiff because he's got a contingent interest in the outcome of the case, that's a serious problem for justice.
Oh, Ms. Wilson, press your button one more time. There you go.
And then I think you also mentioned at the damages presentation, would you know, so would you use this information, I'm thinking like at the motions in limine stage?
Yes. It's so
Can you talk
yes.
about that?
And I would have to really, honestly, I'd have to analyze the effects of this bill in terms of what strategy would come from it. Clearly, we have a lot of the information the bill addresses in some of these cases. What I have done is I've shown the court where the guy had more info in his file than he was supposed to have and forced a proper disclosure. That's one strategy I know I would use. With respect to the bills that are being inflated, we would probably use an expert who would contextualize the charges and compare the amount that the doctor had accepted in satisfaction of his loan with the reasonable and necessary charges in the area. And if he's sold them to the funding company for a lot more than the reasonable and necessary charges in the area, that's essentially data for the jury to take back with it and discuss. And I don't know what a jury would do with that yet. That's not known.
Thank you, Mr. Matthews.
Thank you, sir.
Appreciate you coming today. All right. Rich Resigno? Tell me how I butchered that. Come on up and say your name correctly.
Absolutely.
And good to have you today. Please introduce yourself and tell us who you're with.
I'm sorry, I've just stolen the wrong number. That says do not remove.
I don't think I'm going to use it, but thank you, Chairman. Committee. My name is Rich Resigno. I'm president of Omni Healthcare Financial. So I'm here representing the medical funding industry, also representing the APA, Association for Patient Access. I really don't know where to start here after Mr. Matthews. It was a lot of misinformation there. It's difficult to track, and there's clearly bad actors in this business and in many industries. I mean, that's we're not contesting that. But a lot of what Mr. Matthews mentions here is not medical funding. It's pre-settlement funding, which is a completely different issue than what we have here, and most of it is not even addressed in this bill. This bill is pretty specific about what it wants. But at the end of the day, this is gonna limit care for. I mean, Mr. Matthews said it, for thousands of Georgians. Without medical funding, what are these people gonna do when they can't use their insurance because they don't have $5,000 for a deductible or $10,000, or they'll really have no options. So I think that's important to understand. A couple of other issues that I have with what Mr. Williams presented. Medical bills are medical bills. They don't change. So a doctor, and Mr. Polidor was here, Dr. Polidor, earlier in the session, testified to this as well. He produces a bill, a $100 bill. That's the same bill that he sends to Blue Cross, United, Omni Healthcare. That's the same bill. So the bills that are presented in a case don't change based on the provider. So that's just false. The bills are the bills. They don't go up because a medical funding has purchased them. A medical funding company has purchased them. So it's important to understand that. No, go ahead.
Isn't it possible that there could be a doctor that inflates the bills, that is working in cahoots with another medical funding company, not necessarily yours?
Is it possible? I imagine it could be possible.
Yes.
I
mean, clearly, I think from the evidence presented, that is going on somewhere.
Yeah, I did see also that looked like a new Las Vegas contract there. So we're talking about Georgia cases here, so it's really not relevant. The slide that he illustrated on the percentage, the 45%.
On that issue,
sure.
Yeah, but that's the contract for the contracts that are coming in from all over the country. They're funding providers that contract from all over the country, and their basis for their legal jurisdiction may be another state, not even the state of Georgia, and not even having terms that would be enforceable by the laws of the state of Georgia. So I've spoken with several funding companies that are from Chicago, from Nevada, from Utah, from other states that are doing business in the state of Georgia, and I would think it would be fair to presume, and I'm sure Ms. Matthews can speak to it if you have questions, but that those contracts are based upon the company's domicile, and so it would be Nevada, it would be Illinois, it would be some other state.
Mr. Resigno, Resigno. Mr. Resigno. I'll mess it up 3 or 4 more times. One of the things that it seems to be that everybody agrees upon is that there are good actors and bad actors in this business. And I'm sure the disagreements would be about how many are good, how many are bad, and what constitutes each one of those adjectives. But the question that I have had ever since I have begun to hear about this bill and other bills around is, can the good actors agree upon any legislation that we could pass that would help get the bad actors out of the business? And I'm not expecting you to take your pen and draw something up for me right now, but I'm trying to figure that out. And quite often in my experience here, the way we keep bad things from happening to the people that are doing a good job in this industry is for them to come forward with their own solution as to how we can get rid of some of the bad actors. And that's what I've been looking for, is for the people that understand this best to tell us how to weed out some of the people that are not doing a good job. Does my question make sense to you?
Absolutely.
Yeah.
Absolutely. And, part of the APA does that. We have our bylaws, and we all act as a group in how we manage our business and the contracts we use and the processes and procedures that we go by. But this bill specifically, the fact that the discoverability, it just aids the insurance companies, period. What this will do is limit settlements. It's a fact. The insurance company knows what a funding company pays for medical care, then that's the number. That essentially puts us out of business and puts thousands of patients with no access.
Well, I'm a poor prophet every time I try to predict what this committee is going to do. But they will have a choice over the next several days as to try to pass something or try to pass nothing. And I don't know what they're going to choose to do. I'll hear from them, and they talk to me. They always do. But once again, if you may not be able to, as one of the good actors, be able to come forth and give us a bill or language that will help resolve this problem. But if you don't do that, you leave us with the option of passing a bill that you may not like. And so once again, I'm would ask you as a representative, I'll call you the good guys, help us do something about the bad guys, if you can.
Yeah, no, I think that, parts of the bill we completely agree with, lines 50 and on and many of the lines. The issue that we have is that you're getting into a gray area when it comes to discoverability. When someone uses their insurance, now are those bills discoverable? Why only a medical funding company's bills would be discoverable? Right? I mean, and the bills are the bills. So, like I said, and Dr. Polidor testified to this, his bill is the same bill that he sends no matter where it goes. And, everybody we deal with, that's the way they operate, every doctor. So essentially, that shouldn't be an issue. You follow me? Because the $100,000 in medicals is $100,000 in medicals.
Right.
Okay.
But again, I think it's possible that those bills could be inflated, and I think it's important that that you go off of some kind of standard model like Acumed, where regular lay people can understand when you go to a doctor and you leave the doctor's office and all these numbers are circled on a yellow or a pink sheet, right? Those are CPT codes, right? And the values for those CPT codes, most insurance companies have that information. Most of these databases have that information. And so you can find what is kind of usual and customary for different procedures, whatever procedure you're having. In fact, there are codes. There's an international set of codes that is different from the CPT codes, that there's actually an international medical code if you get bitten by a parrot. I just live with an orthopedic surgeon, so I know these weird facts. But wouldn't it be possible for y'all to come forward with your policies and procedures as a group to share with Chairman Fleming and with the committee to help us develop something that's fair, but something that, again, a judge or a jury can determine whether something's reasonable or not. Because you're right, the bill is the bill, but most people don't understand that there are standard numbers here that are available that are not very hard to find. But most people just accept whatever the doctor gives you. If the doctor gives you a bill for $250,000, but he only did a discectomy on your back and it probably should only have been $2,500, most people are not going to know the difference. But you guys, being in the industry, I would think could come forward with a reasonable standard that could be used in your industry to show what is usual and customary, but to show that this is not out of line. This is not inflated 200%. Do you see what I'm saying?
I completely understand what you're saying.
Okay, great.
I think usual and customary is something that's debated from the defense attorneys on all these cases as well. I mean, that's one of their defenses, is that bill is not usual and customary. So what, the system works well when the plaintiff attorney and the defense attorney deal with that issue when they see that. Trying to get, that would be like all the insurance companies agreeing on exactly what to bill for their charges. They don't, that's not a procedure that they...
Right, but I think you can agree on a range, right? I think you could agree on a range.
And to your point, we, back to being one of the good guys, if we don't contract with doctors that bill, 10 times Medicare or 15 times Medicare. So that's part of how we operate.
And that's great, and I appreciate that you
don't.
don't.
A law,
but we want to be able to make it so that people can't go to those physicians that are billing ridiculously, or having the free market actually weed those people out.
Mr. Welch.
Yep.
Thank you. Mr. Signo, I appreciate where you're coming from and wanting to have a continue the business you're in and do it for the right reasons to help those that are underinsured or might otherwise not have insurance. But there are a few things that you've said, though, that are not correct with respect to this bill. You said this is a pre-settlement bill, but yet that's exactly what's part of the definition of medical funding in the bill. It contemplates both that pre-settlement by its very language, and it also contemplates an ultimate resolution. So it does actually match with what Mr. Matthews was saying. And then secondarily, I wanted to point out that this bill is targeting the contracts that go to the underlying bias that may exist by a doctor who becomes a witness. And so the bills are part of it in terms of debating the accuracy of those bills and whether they're customary or usual. But this goes to exposing that there's a contract, and are these players playing in separate worlds where the funding company is being the funding company and providing financing. The doctor is doing the medical treatment and performing that duty within those guardrails and not performing this. And I know you don't have the doctors that do this, but the doctors that are now engaging in the decision making of making medical decisions based upon financial motives. And then the lawyers that are engaging in a process by which they are directing their clients down a road that is not in their best interest, but in the best interest of the lawyer, the doctor, and possibly the funding company. And I think that area is so ripe for unscrupulous behavior, and that I think it merits us looking at this, if for no other reason than just simply to protect Georgians who are in the most vulnerable state that they can be in and susceptible to being taken advantage of, predatory lending in effect in this situation, because the need for medical attention may be so great, or the illusion of what, number one, that they're going to get better treatment, faster treatment, quicker and more effective treatment, but on the presumption that their claims are going to cover that. And so in your case, you're dealing with doctors that are going to provide the right treatment, they're going to do it for the right reasons in medical, and providing that medical advice. But there are clearly people or companies, funding companies, individuals, and doctors that are not engaged in it. So I think that goes back to what Chairman Silcox is saying and Chairman Fleming are saying, is that we need some guidance to help us, formulate the best measures to regulate the industry, not with the intent of putting it out of business, not with the intent. And then, and it does concern me that may lead to this with this bill. I'm concerned about that, but at the same time, I have, the possibility. It doesn't equate that if other states are doing this and the information is discoverable and the medical fund needs continue, that doesn't equate with an outcome that this bill would result in the shuttering of the medical fund business in Georgia. But what we are seeing is that that the individual Georgians could be taken advantage of, and if that's happening, and clearly it is happening right here in Atlanta, with what we've seen from Mr. Matthews, that troubles me greatly. So I just echo the sentiments that both chairmen have said, that I think we need to work on a regulatory solution that addresses this, and if not this bill, then some other form.
Yeah, I appreciate that.
Closing comments?
Yeah, sure. I just the pre-settlement funding portion of that. Can you point out the line real quick? Because that essentially is a different business than medical funding. Medical funding is we purchase a bill for a certain amount, and it doesn't have an interest rate attached to it like what was presented. So that's materially a different or a financial instrument. That's one issue. I just think we just need to let the juries decide this like we do. The juries are presented with the information, and whether it's insurance, medical funding, and let the juries are smart, and let them decide what someone should get and what they shouldn't. Limiting this will limit access at the end of the day. It's just what will happen. Insurance companies know what the costs are, and that becomes the cost. And there's no way for funding companies to operate at that point. So, but to your point, there's got to be something. Maybe we can work out a compromise for the next session, or come up with a framework. Because I don't disagree with you. Some of the things that Mr. Williams put up there is alarming. And so, we understand, but I don't think that some of those things there are not covered in this legislation.
Yeah, and the original bill would have allowed all this into evidence, so that you would have really allowed the juries to see the entire panoply of cost, whether fabricated or not. The original bill would have allowed for all that in as evidence, and we stepped back from that because that interfered with incentivizing people to try to get care quickly. So and good care. So I think that's we've tried to step back from that, but opening up for the discovery so that all parties can see what is the actual value of the case, as opposed to an unscrupulous inflated value, is really important, and to disincentivize that behavior is really important. But so I think I would agree with you on that point about letting the jury see more of the information than they're currently seeing, without 2 years of discovery law litigation, which comes back on us as ratepayers. It affects the victim as well, or the injured party as well, because they're not having their case resolved. And who knows what the collection rates would be thereafter. But with all that said, I think that that I did want to say this session is particularly difficult to work through, because we have Senate measures that are also impacting this area, and it puts individuals at a difficult disadvantage relative to trying to have an open discussion about this when you've got bills that may be coming over from the Senate. So I wanted to say that because I wanted to acknowledge that we've had some discussions privately about that. We've had those publicly as well in the subcommittee, that the posture is difficult during this session, and maybe a study committee is a better way to go about it. Maybe not, but I'll leave that with the will of the committee.
Well, what I would say to you, and that is that, Chairman Welch, I would ask you to take the portions out of your bill that don't allow you to get a vote to move that bill out of this committee. And I'd like to see us move something. And if you can craft a bill that can get majority vote out of this committee, I'd like to see us send it to rules. So I don't know if you can do that. But I would ask you to give it a try. My hope would that y'all would help him to the extent that you could. The good guys help us do something now about the bad guys. I've heard over and over again people say that the disclosure, the transparency portion of this bill is good. I think that's the term that I've heard. And if there are good portions to it, I'd like to see us move it. And because that would be a signal to the bad guys that, straighten up your act, because something's going to happen with this as things begin to move to the process. Okay.
Yeah, just one final, I understand that when doctors sell their bill or we fund their bill, they don't have a financial interest in that bill any longer. So I know that some of that's been kicked around, that they have an interest in the case. They have an interest in the case if they hold their bill and they do not fund it, because then they don't have their bill paid.
But if they don't participate in the proceeding after they sell their bill, they may not get another case. I think, isn't that the idea?
No,
That
they
if
get
you don't cooperate, you don't
subpoenaed
get referrals.
No, they get subpoenaed by the court to testify. That has nothing to do with a funding company or a plaintiff attorney. You follow me? So I understand what you're saying.
Bottom line is they're good doctors, and there's so few that are doing some things that shouldn't be done in this, and we've seen some examples of that day. Right.
Completely
And
agree.
once again, my request to you is help us figure out what we can do about the ones that aren't doing what they should
Fair
do.
enough.
Okay. All right. Thank you for coming today. We appreciate it. We will stand adjourned.